Assalamualaikum and very good morning to everyone. I hope that you all are doing good. So welcome back to our lecture class. Alright, for today we are going to discuss another type of law of tort under trespass to person, which is forced imprisonment. Okay, and then the second part of our lecture today will be the defenses, okay, for trespass to persons, meaning that these defenses can be used as defense to the default party, okay, if there is an assault, battery, and forced imprisonment. Right, so the learning outcomes for today is first, at the end of the lesson, student is able to understand what is meant by forced imprisonment. Second, student is able to identify all the elements of forced imprisonment. Third, students is able to apply the legal principles to the given facts and demonstrate critically when answering problematic questions. And last but not least is student is able to identify the defenses available for trespass to person. So let's continue with the definitions of forced imprisonment. Okay, literally forced imprisonment here means unlawful constraint, okay, or when there is a constraint without any legal justification. Sometimes it may restrict your freedom of movement, okay, or this is also called as a detention without reason, okay, without lawful authority. So basically, forced imprisonment means the infliction of bodily restraint which causes the confinement of the plaintiff within an area determined by the defendant, which is not expressly or impliedly authorized by law. Okay, so it is obviously okay for you to prove that the restraint, the act of restraint, the act of confinements must be done without any lawful authority, okay, or without any lawful justification. So, the interest that is protected is that of freedom from confinement, and it maintains a person's liberty to unrestricted movement. Okay, but please bear in mind that okay, if someone is holding your arm but you are actually able to break free, then it is not amount to a forced imprisonment because you have the way to release yourself from that particular person. Okay, I'll give you an illustrations as you can also refer to your manual book. Okay, for example, when Monica, James and their friends were having a great time at a party, after realizing that Monica was really drunk, James and his other friends decided to leave the party and prank Monica as if she was detained in a room. He was then grabbed her arm and kept her in a room while the other friends locked the door. James didn't do anything to Monica. However, she was scared and unable to leave for several hours. So what do you think? Do you think that these situations is amounting to a forced imprisonment? Yes, okay. This is called forced imprisonment as they physically detained her and she legitimately believed that she could not leave, okay, since the door was locked. Therefore, a person locking another person in a room without their permissions is considered as forced imprisonment. Okay, in order to prove forced imprisonments, the three elements here must be fulfilled. First, the mental state of the defendant. In other words, the intention of the defendant to to do a forced imprisonment. And then to restrain, the restraint must be a direct consequence of the defendant's act. Okay, must be voluntarily done by the defendant. And third element is the restraint must be a complete restraint. So there is no other reasonable way for the plaintiff to release himself. Okay, so here the three elements. Okay, now let's discuss the first elements of forced imprisonment. The defendant must have committed the restraint intentionally. Defendant must have intention to restrain the plaintiff. So he must intend to do an act which directly results in the confinement of the plaintiff. Okay, you may refer to the case of W. Alpinston against Lee Langsang. Okay, the court held that forced imprisonment cannot be established through negligence, as intention of the doer is a prerequisite. So, under law of forced imprisonments, you must prove that the defendant has intention to do an act of forced imprisonment. Okay. Move on to the next element. There must be direct consequence of the defendant's act. Okay, the confinements, the restraint must be a direct consequence of the defendant's act. So only the person who directly causes the confinement may be successfully sued for forced imprisonment. And he may be liable either because he himself confined or imprisoned the plaintiff, or that he had instigated or incited another person to confine or imprison the plaintiff. In other words, even he himself not actually do the restraint or confinements, but he is the one who gives the instructions to the defendant, so he also can be considered as a forced imprisonment. Okay, to commit forced imprisonment. Okay, as you can see, we have landmark case for forced imprisonment in the case of Harnett against a bond and another. Okay, you may refer to your manual book and the facts of the case. The plaintiff lived in an asylum run by defendant 2, and the plaintiff was given a month's leave, but defendant 2 was given the discretion to call the plaintiff if he felt that the plaintiff could not look after himself during that 1 month. So they give 1 month's leave to the plaintiff, but defendant 2 has authority to call the plaintiff back if he thinks that the plaintiff is still unsound. Okay, means that cannot take care of himself, for example. Okay, on his second day out, the plaintiff went to his friend's office, and the defendant 1 who was there was of the opinion that the plaintiff was acting strangely. So there was a defendant 1, and he thought that the plaintiff was acting strangely. So he thought that the plaintiff was unsound mind at that time. Then defendant 1 called defendant 2, who asked defendant 1 to make sure that the plaintiff stayed there, as the defendant 2 would send a call to fetch the plaintiff. Okay, in other words, defendant 2 give instructions to the defendant 1 to keep the plaintiff there. And the call arrived some 3 hours later, so it means that there was 3 hours confinement or restraint to the plaintiff. And then the plaintiff was brought back to the asylum. And defendant 2 believed that the plaintiff was insane and did not let him out anymore for 9 years. Okay, and then defendant 2 restrained plaintiff for 9 years. And later, after 9 years, he was finally proven sane and released, as the jury was of the opinion that the plaintiff was sane 9 years previously at the time of committal to the institutions. Okay, so they have proved that at the time the restraint made against the plaintiff for 3 hours, okay, and then 9 years in the asylums, Okay, the plaintiff is actually sane or sound mind. So what is the court held of the case? Defendant 1 was liable for false imprisonment during the 3 hours, and defendant 2 for the 9 years restraint. So even defendant 1 is not the person who give the instructions, okay, but he commit the restraint, he commit the confinements against the plaintiff, so he is also considered as liable for forced imprisonment. And the last elements that must be proved is there must be a complete restraint. Plaintiff must be restrained completely with no alternative route to escape. For example, in the case of Bird and Jones, the facts of the case is there was a regatta and a part of a bridge was appropriated for seats. Sorry. The plaintiff insists on passing along the part so appropriated, and the defendant stopped the plaintiff but told him that he could take another route to proceed to the other side of the bridge, and the plaintiff refused and remained there for half an hour, and then later he wanted to take action against the defendant for false imprisonment. So in this case, the court held that there was no false imprisonment as the restraint was not complete. The general principle is when there is a reasonable way out, it must be used. So there is an additional route available against the plaintiff, so he can use that route. If the plaintiff does not use it, he cannot claim that his liberty has been restrained. And the court was of the view that forced imprisonment is a total restraint of the liberty of the person for however short a time and not a partial obstruction of his will. So it must be complete restraint. Okay, however, despite we have the 3 elements of forced imprisonment, okay, we need to consider this aspect as well. Okay, another aspect is knowledge of restraint. So whether the plaintiff must have knowledge, whether the plaintiff must aware that he has been restrained by the defendant. The answer is a plaintiff does not need to know he has been restrained because as discussed in the case of Mirroring against Graham White Aviations Limited, a person can be imprisoned without him knowing it. For example, while he is asleep, in a state of drunkenness, unconscious, or a lunatic. Lunatic means a gila, unsound mind. So the questions of whether he is aware of the imprisonment or not will only result in the variations of the amount of damages. Okay, yes, court will consider whether he has knowledge, whether he is aware, in order to determine the amount of compensation. Okay, so that's all, the 3 elements and one aspect to be considered in order to prove that is forced imprisonment. Okay, now let's continue with the defenses that are available for trespass to person. So this is also include a tort of assault and tort of a battery. And defenses here available to the defendant in order to defend himself, to free himself from the remedy sought by the plaintiff. So we can assume that the elements of trespass to person have been fulfilled by the plaintiff, okay, successfully fulfilled by the plaintiff, and then now defendant wants to defend himself. So among defenses available to defendants are self-defense, voluntary consent, a legal authority, lawful arrest, and a spot. Okay, for example, self-defense. Okay, it is lawful for a person to use reasonable degree of force to protect himself or any person against any unlawful use of force. Force not reasonable if unnecessary or disproportionate to the harm to be prevented. So it must be done necessarily. Okay, bila terpaksa, then you can use the force. In the case of a chaplain of grace in case, the court held that one should not wait to be punched by the attacker. He may use any reasonable degree of force as a protection of himself. So now when he applied force, when he also punched the defendant, this is considered as self-defense. Another example of defense is voluntary consent. Consent must be genuine, not obtained by force or threat. Okay, so voluntarily given by the plaintiff. For example, those who participated in sports consent to reasonable conduct within the rules of the game. Okay, an example, boxing. In boxings, okay, boxers are agrees to violent bodily contact typical of the sport, but not to deliberate for play. So it is also based on the rules of the game. Okay, defense of legal authority or lawful arrest. Okay, as the police, okay, has a defense of legal authority for the purpose of enforcement of criminal law. Police and private citizens have the right to make arrests and thereby interfere with the rights of others, but they must follow the federal constitutions and criminal procedure code. And last but not least is the defense of sport. Those who participated in sport consent to a reasonable conduct within the rules of the game. Okay, so now you can refer to the example of a voluntary consent just now. Okay, in a boxing tournaments. Normally, this defense, it must be involve considerable hostility and deliberate punches. Alright, so I hope that you all are clear with the explanations on the forced imprisonments, the 3 elements that must be fulfilled by the plaintiff, and also you have to consider another aspect, which is knowledge of the plaintiff. Okay, and forced imprisonment also can be asked in problem-based questions, so you have to answer using a formula of ILAC, issue, law, applications, and conclusions. So guys, if you have any questions, if you are unclear regarding these explanations, you may text me. Thank you very much. Assalamualaikum.